Fraudulent, forged, fabricated. Those are the three words that just echoed through a British courtroom, and they were aimed directly at Prince Harry, Duke of Sussex, the man who has spent years positioning himself as the ultimate victim of media corruption. A new witness has taken the stand under oath and delivered testimony so explosive that legal experts are demanding to know why criminal charges have not already been filed. According to this witness, Harry allegedly submitted fraudulent and forged testimonies to the court. Not speculation, not tabloid gossip. Sworn statements in a United Kingdom courtroom that should have brought this entire charade crashing down around his ears. Let us be absolutely clear about what is being alleged here. This is not some minor procedural issue or a technical legal dispute. This witness is claiming that a member of the British royal family, sixth in line to the throne, deliberately submitted false evidence to manipulate the outcome of his lawsuit. Under any normal circumstances, allegations of this magnitude would trigger an immediate halt to proceedings and a criminal investigation under the Perjury Act of 1911. The courts do not take kindly to being lied to. Careers have been destroyed. People have gone to prison. The integrity of the entire justice system depends on witnesses and plaintiffs telling the truth. But here is where things get truly infuriating. Sources familiar with the proceedings say the judge's response to this bombshell testimony was, to put it mildly, underwhelming. Instead of the dramatic intervention you would expect when someone alleges court fraud, the case appears to be proceeding as if nothing happened. One legal observer put it bluntly, calling it one of the most baffling judicial responses they have witnessed in decades of courtroom experience. Another source close to the matter described the atmosphere as surreal, noting that everyone in that courtroom knew the gravity of what had just been alleged, yet the wheels of justice barely stuttered. Prince Harry walked into this legal battle convinced he would emerge as a crusader for truth, the brave whistleblower exposing the rot at the heart of British tabloid culture. He painted himself as David taking on Goliath, the little guy standing up against powerful media empires that had allegedly ruined his life. The narrative was compelling, it was emotional, it was frankly great television, and now it may all be unraveling in the most spectacular fashion imaginable. The hunter has become the hunted, and the man demanding accountability from others may soon be forced to answer for his own alleged deceptions. The irony is absolutely staggering when you think about it. Harry has built his entire post-royal identity around being a truth teller. He wrote a memoir called Spare that promised raw honesty. He sat for countless interviews claiming he wanted transparency. He stood in courtrooms demanding that newspapers be held responsible for their alleged lies. And now a witness has sworn under oath that Harry himself allegedly submitted fraudulent evidence. You genuinely cannot make this stuff up. If this were a Netflix script, the producers would reject it as too on the nose. But the judge's puzzling response to these allegations is just the beginning of this story. And to understand why Harry should be genuinely terrified right now, we need to examine what he has already admitted under oath. The gravity of this witness testimony cannot be overstated, and anyone dismissing it as tabloid fodder is either willfully ignorant or hopelessly naive. This is not some anonymous source whispering to a gossip columnist at a cocktail party. This is a sworn statement delivered in a United Kingdom courtroom, subject to cross-examination, recorded in official transcripts, and carrying the full weight of legal accountability. The witness put their own neck on the line to make these allegations, knowing full well that lying under oath carries serious criminal penalties. That alone should tell you something about the strength of their conviction. Harry's lawsuit against Newsgroup newspapers spans the period from 1993 to 2011, covering nearly 2 decades of alleged phone hacking and unlawful information gathering. He has positioned himself as a victim of systematic media abuse, claiming that journalists illegally accessed his private communications and published stories based on stolen information. It is a compelling narrative, and for years the British public has been largely sympathetic. After all, who among us would not be outraged to discover that reporters were listening to our voicemails? The instinct to root for Harry in this fight has been powerful, but this new testimony threatens to flip that entire narrative on its head. If the allegations are true, if Harry did indeed submit fraudulent and forged testimonies to support his case, then we are not looking at a victim seeking justice. We are looking at someone allegedly trying to manipulate the court system to achieve a predetermined outcome. Sources close to the legal proceedings describe the implications as catastrophic for Harry's credibility. One insider noted that once allegations of fabricated evidence enter the picture, everything the plaintiff has previously claimed becomes suspect. Every document, every testimony, every piece of evidence Harry has submitted must now be viewed through a lens of profound skepticism. The prince who positioned himself as crusading against corruption may now face accusations of perpetrating corruption within the very courts he sought to weaponize. Let that sink in for a moment. This is not a minor credibility issue that can be spun away with a sympathetic interview or a well-crafted press release. This is the kind of allegation that destroys legal cases, ends careers, and occasionally results in criminal prosecution. Harry has spent years demanding accountability from tabloid editors and journalists. He has called for investigations, reforms, and punishments, and now the spotlight of accountability is swinging back toward him with brutal force. What makes this situation even more precarious for Harry is the context of who he is fighting. Newsgroup Newspapers is owned by Rupert Murdoch, one of the most powerful media moguls on the planet with virtually unlimited resources for legal warfare. These are not opponents who will quietly settle to make embarrassing allegations disappear. They have armies of lawyers who will pick apart every inconsistency, every contradiction, every questionable piece of evidence Harry has ever submitted. If there are holes in his case, they will find them. If there are lies in his testimony, they will expose them. To fully grasp why Harry is reportedly shaken to his core, we need to examine something he was confronted about during cross-examination, a mysterious alias that raises more questions than it answers. Harry was confronted under oath about the alias Mr. Mischief, and his response sent immediate alarm bells ringing throughout the courtroom. According to reports from those present during the testimony, lawyers for the defense asked Harry directly whether he had used this pseudonym to communicate with individuals connected to the very media organizations he is now suing. It is a simple question, really. Either you used an alias or you did not. Either you sent those messages or you did not. There is no gray area here, no room for nuance or interpretation, and yet Harry's answer was anything but straightforward. Under oath, with the full weight of perjury laws hanging over his head, Harry claimed that he either never used the alias or simply could not remember sending those text messages. Let us pause here and consider the absurdity of this response. This is a man with a memory sharp enough to recall specific conversations from decades ago when they support his narrative. This is a man who wrote an entire memoir filled with precise details about childhood events, family disputes, and personal interactions stretching back to his earliest years. But when asked about communications that might undermine his case, suddenly the fog of forgetfulness descends. Sources familiar with the proceedings suggest that lawyers would not have raised this alias issue unless they possessed evidence contradicting Harry's claims. You do not ask a prince about a specific pseudonym on a fishing expedition. You ask because you have receipts. One legal expert following the case noted that the defense team appeared supremely confident when broaching this subject, describing their demeanor as that of lawyers holding a royal flush. If they can prove Harry used this alias to communicate with journalists while simultaneously claiming to be a victim of those same journalists, the implications are devastating. The man suing for unlawful information gathering conveniently cannot recall communicating with the very reporters he is accusing. Allow me to translate that from legal speak into plain English. Harry wants us to believe that he has no memory of potentially incriminating communications, but perfect recall of every instance where he was allegedly victimized. That is not how memory works, folks. That is how selective testimony works. That is how someone who is allegedly trying to have it both ways operates when caught in an uncomfortable situation. Critics of Harry have seized upon this memory lapse as evidence of a broader pattern of convenient forgetfulness. When details help his case, Harry remembers everything with crystal clarity. When details might hurt his case, suddenly the details become fuzzy, uncertain, impossible to confirm or deny. This is not the behavior of someone confident in their truth. This is the behavior of someone allegedly trying to navigate around uncomfortable facts without technically committing perjury. But here is the thing about courts. Judges and juries are remarkably skilled at detecting exactly this kind of evasive maneuvering. But this memory lapse becomes exponentially more suspicious when you examine what Harry definitely did remember doing, specifically a text message to his private secretary that exposes his alleged pattern of deception. A 2018 text message to Jason Knauf, Harry's private secretary at the time, has emerged as perhaps the most damning piece of evidence regarding the prince's modus operandi. This is not hearsay or speculation. This is a direct communication from Harry himself, preserved in digital form, instructing his own staff on how to deceive the public while maintaining plausible deniability. The contents of this message should concern anyone who still believes Harry operates in good faith. In the text, Harry explicitly instructed Knauf to share information with Omid Scobie and Carolyn Durand, the authors of Finding Freedom, a book that was marketed as an independent biography of Harry and Meghan. The book painted them in an overwhelmingly favorable light, portraying them as victims of a cruel royal institution and a racist British media. For months after its publication, Harry and Meghan publicly maintained that they had nothing to do with the book. They denied cooperating with the authors. They suggested that any accurate information in its pages was simply the result of good journalism. But Harry's text to Knauf tells a very different story. The direct quote, according to court documents, reads as follows: "I totally agree that we have to be able to say we did not have anything to do with it. Let those words wash over you for a moment." Harry is not saying they actually had nothing to do with the book. He is saying they need to be able to claim they had nothing to do with it. The distinction is everything. He is explicitly strategizing about how to feed information to these authors while constructing a false narrative of non-involvement for public consumption, Legal experts have pointed to this text as evidence of what they call a clear modus operandi. Harry allegedly operates through third parties, feeding them information and narratives while maintaining the ability to deny any direct involvement. It is a sophisticated form of media manipulation, and it completely contradicts the image of a naive prince victimized by cunning journalists. If anything, this text suggests Harry understands media manipulation quite well. He just prefers to be the one doing the manipulating, rather than being manipulated. Sources close to the royal household were not surprised by these revelations. One insider noted that this kind of strategic communication was standard operating procedure for the Sussexes, describing it as a constant game of feeding stories while claiming ignorance. Another source was more blunt, suggesting that Harry learned to play the media game better than anyone gave him credit for, then cried foul when the media played back. The hypocrisy, according to these insiders, is breathtaking. What makes this evidence particularly relevant to the current case is that it establishes a pattern. If Harry was willing to coordinate with authors while publicly denying any involvement, what else might he be willing to do? What other denials might be equally hollow? These are the questions that lawyers are now asking, and Harry has no good answers. And Harry is not the only Sussex caught lying under oath about these exact same authors, because Meghan Markle already blazed this trail of alleged perjury. Meghan Markle was already exposed for committing what many legal experts describe as clear perjury in United Kingdom courts, and she faced absolutely zero consequences for it. This is not opinion or interpretation. The evidence is documented, verified, and a matter of public record. And the complete absence of any legal repercussions has set a dangerous precedent that Harry now appears to be exploiting for his own benefit. In a sworn written statement submitted to the court during her lawsuit against Associated Newspapers, Meghan categorically denied any involvement with Omid Scobie and Carolyn Durand's book Finding Freedom. She claimed under oath that she had not cooperated with the authors and had no knowledge of what the book would contain. This was not an ambiguous statement subject to interpretation. It was a clear, unequivocal denial designed to support her legal case, and it was, as subsequently proven, entirely false. Evidence later emerged proving that Meghan had actually communicated with Scobie and Durand for approximately 6 to 7 months during the writing of their book. She had provided information, background, and context. She had, by any reasonable definition, cooperated extensively with the authors whose book she claimed to know nothing about. When confronted with this evidence, Meghan was forced to apologize to the court and claimed she had simply forgotten about these extensive communications. Forgotten. 6 to 7 months of cooperation with authors writing a book about her own life, and it somehow slipped her mind. Let us be brutally honest about what happened next, which is to say absolutely nothing. Rachel Meghan Markle faced no criminal charges for her false statements. She was not prosecuted for perjury. She was not held in contempt of court. She was not subjected to any meaningful legal consequences whatsoever. The judge accepted her convenient memory lapse explanation, and the case proceeded as if a clear falsehood under oath was simply a minor procedural hiccup rather than a potential crime. The message this sent was unmistakable. If you are famous enough, wealthy enough, or connected enough, you can apparently lie under oath in British courts without consequence. One legal commentator described it as one of the most troubling judicial decisions in recent memory, noting that it essentially created a two-tier justice system where celebrities play by different rules. Another observer was more direct, suggesting that ordinary citizens would be facing criminal charges for far less serious misrepresentations. Harry has clearly taken notice of his wife's experience. Why would he fear consequences for alleged fraudulent testimony when Meghan walked away from her perjury accusations without so much as a formal reprimand? The precedent has been set, the template has been established, and critics argue that Harry is now following Meghan's playbook with confidence that the same immunity will protect him. But this pattern of Sussex immunity reveals something deeply troubling about the British legal system itself, and what the presiding judge has allegedly done to keep Harry's case alive. The presiding judge in Harry's case has allegedly violated two major legal principles that should have stopped this lawsuit in its tracks, and the reasons behind these apparent violations remain deeply mysterious. Either the judge is showing extraordinary favoritism toward a royal plaintiff, or something far more troubling is happening behind the scenes of British justice. Neither explanation is comforting. The first alleged violation concerns statute of limitations law. Harry's claims stretch back to 1993, which means some of the alleged offenses occurred more than 3 decades ago. British law contains clear time limits on when civil claims can be brought precisely because evidence degrades, memories fade, and witnesses die. These limitations exist to prevent exactly the kind of stale claims that Harry is bringing. Yet somehow, despite claims that are years and in some cases decades past the deadline, the judge has allowed Harry's case to proceed. Sources familiar with UK civil procedure describe this as highly irregular, with one legal expert calling it virtually unprecedented for claims this old to survive summary judgment. The second and far more serious alleged violation concerns the witness testimony about fraudulent evidence. Under the Perjury Act of 1911, any credible allegation that someone has submitted false evidence to a court must be referred to the Crown Prosecution Service for investigation. This is not a discretionary matter. This is not something judges can choose to ignore because the defendant is famous. The law is clear. Allegations of perjury and evidence tampering are criminal matters that require criminal investigation. Yet according to sources close to the proceedings, no such referral appears to have been made despite the witness's explosive testimony. Let us consider what this means in practical terms. A witness has sworn under oath that Harry allegedly submitted fraudulent and forged testimonies. This allegation, if true, constitutes a serious criminal offense that could result in imprisonment. The judge heard this testimony firsthand, and yet the case continues as if nothing happened. One legal observer described this as a failure of judicial duty so profound that it calls into question the integrity of the entire proceeding. Another was more measured but equally concerned, noting that the appearance of impartiality is just as important as actual impartiality, and this judge's handling of the fraud allegations fails both tests. Why would a judge bend the rules for a prince who no longer enjoys official palace protection? Harry is not a working royal anymore. He has no constitutional role. He has publicly attacked the institution his grandmother represented for 70 years. By all logic, he should be treated as any other wealthy litigant pursuing a civil case. But logic does not appear to be driving the judicial decisions in this courtroom. Something else is at play, and critics are demanding answers that are not forthcoming. But to truly understand the paradox at the heart of this case, we need to examine the extraordinary privilege that has defined Harry's entire life. Harry claims he is a victim, the perpetual underdog fighting against powerful forces determined to destroy him. But his entire life has been defined by extraordinary privilege that ordinary British citizens could never dream of enjoying. The man demanding accountability from others has rarely, if ever, been held accountable himself, and the pattern stretches back decades before Meghan Markle ever entered the picture. Consider his military career, which Harry has repeatedly cited as evidence of his ordinary guy credentials. He is the only soldier in modern military history admitted to the Royal Military Academy Sandhurst, despite not meeting the minimum grade requirements. Let that sink in. Thousands of young men and women are rejected from military academies every year because their grades fall short of the standard. But Harry, with qualifications that would have disqualified anyone else, was welcomed with open arms. His blood was worth more than his academic record. His surname opened doors that his transcript would have kept firmly closed. But the privilege extends even further back. While still a student, Harry was embroiled in a cheating scandal that would have resulted in expulsion for any commoner. Reports emerged that a teacher had written one of his essays for him, while another had provided substantial help with artwork submitted under his name. For ordinary students, academic dishonesty of this magnitude means the end of their educational careers and a permanent stain on their records. For Harry, it meant a brief flurry of embarrassing headlines followed by continued privilege and protection. And then there is the matter of substance abuse. Harry himself has admitted to extensive drug use during his younger years, including cannabis and cocaine. He has written about these experiences with remarkable candor in his memoir. Yet despite this well-documented history of illegal drug use, Harry was allegedly never subjected to military drug testing. One source with knowledge of military procedures described this as extraordinary, noting that random drug testing is standard protocol and that any soldier caught using cocaine would face immediate discharge. The rules that apply to everyone else simply did not apply to the prince. This is the man now demanding that others face consequences for their alleged misdeeds. This is the man positioning himself as a crusader for accountability and transparency. The hypocrisy is not just notable, it is defining. Harry has spent his entire life escaping consequences that would have destroyed ordinary people. And now, even as witnesses testify about alleged evidence fraud, he appears confident that the same immunity will protect him once again. Now that Buckingham Palace no longer covers for him, Harry appears to have found a new protection strategy, one that plays out dramatically in the courtroom itself. Harry broke down crying in court during recent proceedings, and the media immediately ran with the emotionally sympathetic coverage he clearly desired. But the circumstances surrounding these tears reveal something far more calculated than genuine grief. According to those present, Harry was not crying about his own case or the allegations against him. He was crying about Meghan's alleged misery at the hands of the British press. Meghan Markle, who was not even around during the 1993 to 2011 period covered by this lawsuit. Let us examine the logical disconnect here. Harry is suing newspapers for actions that allegedly occurred before he ever met his wife. The case has nothing to do with Meghan's treatment by the media. She is not a party to this lawsuit. Her experiences are legally irrelevant to the claims being adjudicated. And yet, when Harry needed to generate sympathetic coverage, when the allegations of fraudulent evidence began making headlines, he conveniently redirected the emotional focus to his wife. It is, according to critics, a masterclass in manipulating media narratives. Major media outlets across the board ran with the story exactly as Harry apparently intended. Headlines screamed about poor Harry crying for his wife. Commentators discussed the emotional toll the media has taken on the Sussex marriage. The actual substance of the case, including the explosive witness testimony about alleged fraud, was buried beneath avalanches of sympathetic coverage about princely tears. One media analyst described it as textbook distraction technique, noting that Harry knows exactly which buttons to push to generate favorable coverage. Critics have taken to calling these outburst traitor tears emotional manipulation designed to distract from the real legal issues at stake. They point to the timing of Harry's breakdown, coming precisely when negative coverage about his case was reaching critical mass. They note that crying about Meghan redirects attention from Harry's own credibility problems, and they argue that a prince who has spent years crafting his media image knows exactly how these moments will play in the press. The tears may be real. The strategic deployment of those tears appears to be anything but spontaneous. Sources close to the proceedings describe a pattern of emotional displays that coincide suspiciously with damaging revelations. One insider noted that Harry seems to have a breakdown whenever his legal team needs to change the subject, characterizing it as remarkable timing if nothing else. Another observer was less diplomatic, suggesting that these tears are calculated performances designed to manipulate public sympathy. Whether that assessment is fair or not, the correlation between negative coverage and emotional displays is difficult to ignore. What the mainstream media consistently refuses to report is what this case really means for every British citizen who values freedom of expression. This case is not merely about one privileged prince's grievances against tabloid newspapers. It is about fundamental rights that affect every British citizen, and the stakes could not be higher. The United Kingdom has no codified freedom of speech protections. It has no constitutional right to privacy. These protections, such as they exist, come down to judicial precedent and the decisions of individual judges. What happens in Harry's courtroom could reshape British law for generations. Celebrities, politicians, and royals have long sought to control their public images while hiding unflattering truths from public view. They have armies of lawyers, unlimited resources, and the patience to pursue legal warfare against anyone who publishes information they would prefer to keep hidden. For decades, the threat of ruinous litigation has been used to silence legitimate journalism and suppress stories that serve the public interest. Harry's case represents the latest and perhaps most dangerous escalation of this trend. Consider the historical parallel to Jimmy Savile, the beloved television presenter who was revealed after his death to be one of Britain's most prolific predators. For decades, journalists knew about Savile's crimes. They gathered evidence, they prepared stories, and those stories were suppressed, killed by lawyers, buried by executives terrified of the legal consequences. Savile's wealth, fame, and connections protected him. The victims had no voice because journalism that might have exposed him was deemed too legally risky to publish. This is what happens when the powerful can use courts to silence scrutiny. This is what happens when wealthy plaintiffs can pursue litigation not to seek justice, but to punish anyone who publishes information they dislike. The chilling effect on journalism is profound and measurable. Editors kill stories rather than face years of legal warfare. Reporters self-censor rather than risk their careers. The public remains ignorant of truths that might embarrass the powerful. Harry frames his lawsuit as a quest for accountability, but critics argue it is actually about control. He wants to determine what can be written about him. He wants to punish outlets that published unflattering coverage. He wants to establish precedents that will make it easier for future celebrities to suppress legitimate journalism. One press freedom advocate described the implications as potentially catastrophic, warning that a Harry victory could fundamentally alter the balance between privacy and public interest. The witness testimony about alleged fraudulent evidence puts all of this at risk in ways that should concern everyone who values a free press. If Harry's case collapses under the weight of fraud allegations, it might seem like a victory for journalism, but the damage has already been done. Years of litigation have consumed resources, chilled coverage, and demonstrated to other celebrities that legal warfare works even when you eventually lose. And Harry's reaction to these mounting problems reveals that he knows exactly how precarious his position has become. Prince Harry wanted accountability from the British press. He demanded that newspapers face consequences for their alleged crimes. He positioned himself as a warrior for truth, a crusader against corruption, a victim seeking justice against powerful tormentors. And now, if this witness testimony is to be believed, the man demanding accountability may need to face some accountability himself. The allegations of fraudulent evidence submission are not going away. They are documented in court records. They will follow Harry for the rest of his life. The transformation could hardly be more dramatic. Harry entered this legal battle as a plaintiff, the aggrieved party seeking redress for alleged wrongs. He may exit it as something far less sympathetic, potentially even as a defendant facing criminal charges for the very offenses he accused others of committing. The irony writes itself. The man suing for dishonest journalism allegedly submitted dishonest evidence. The prince demanding transparency allegedly engaged in deliberate deception. The victim narrative crumbles when the alleged victim is accused of victimizing the court itself. If the king's son can allegedly submit forged testimony without consequence, what does that mean for British justice? The question is not rhetorical. It strikes at the heart of what the legal system is supposed to represent. Justice is supposed to be blind to wealth and status. Courts are supposed to treat princes and paupers by the same standards. Evidence tampering is supposed to be prosecuted regardless of the defendant's surname or the size of their bank account. If Harry walks away from these allegations without investigation, the message to ordinary citizens is unmistakable. There is one justice system for the elite and another for everyone else. The witness who testified about fraudulent evidence took an enormous risk. They could face retaliation from Sussex supporters. They could be dragged through media mud by sympathetic commentators. They put their reputation on the line because they believed the court needed to hear the truth. And if their allegations are dismissed without serious investigation, what message does that send to future witnesses who might expose wrongdoing by the powerful? Harry has spent years demanding that others be held to account. He has called for investigations, reforms, and punishments. He has positioned himself as someone who believes passionately in consequences for wrongdoing. Well, here is his chance to demonstrate that those principles apply to everyone, including himself. The witness has spoken. The allegations are on record. The question now is whether British justice has the courage to investigate a prince with the same vigor it would investigate anyone else. Do you believe Harry should face criminal investigation based on this witness testimony, or is he still protected by invisible royal privilege that places him above the law? The evidence is mounting, the questions are multiplying, and the answers matter not just for one privileged prince, but for everyone who believes that justice should mean something more than protection for the powerful. Drop your thoughts below. Like, subscribe, and stay tuned. The next video is waiting, and you will not believe what is coming next.